Trust litigation lawyers, by default, become frequent advocates for the protection of trust beneficiaries and the assertion of their clients' rights. Ongoing complaints regarding the systemic overreach of banks, trust companies, and California licensed professional fiduciaries acting as trustees are made at administrative levels and litigated for the most part at the probate court level. The growing conservatorship reform movement is animated by the all too frequent financial exploitation, physical and emotional abuse visited upon our nation's most vulnerable citizens by conservators and guardians. This reform movement is worthy of its growing public attention. There's no dearth of stories and examples of abuse. There is a dearth of institutional advocates, and individual advocates are limited by time, money, and geographic reach. Still, the stories must be told, and as they are told with time, the spotlight will grow brighter in the legal, non-legal, media, public policy, and legislative fields. The need is growing greater for skilled advocates to advance the cause of protecting the vulnerable. I've made personal efforts in this area by writing 2 books about elder financial abuse, The Wolf at the Door and Alzheimer's Widowed Stepmothers and Estate Crimes. Of course, far more needs to be said. Trustee abuse of beneficiaries may occur by the actions of unlicensed fiduciaries, licensed fiduciaries, banks, or trust companies. I've written extensively about trust beneficiary rights. These rights are important and critical to a functioning estate system. It's one thing when they're violated by unlicensed and unskilled fiduciaries, but it's quite another when the violations are those of a trust company or a licensed fiduciary. California licensed fiduciaries often assume the paid roles as trustees, guardians, estate executors, agents under a power of attorney, and conservators for those who are mentally or physically incapacitated. They're licensed to serve California's most vulnerable population. The system doesn't always work. The Professional Fiduciary Association of California identifies the obligation of a professional fiduciary. The responsibility is unique, essential, and often noble in nature. A fiduciary's role is not merely that of a business manager, decision maker, or guardian. It's also a nurturing bond of trust, concern, and attentive caregiving. A fiduciary seeks to support mental and emotional well-being, reduce the stress of changing circumstances or unexpected events, and most importantly, help each client and their families enjoy a fulfilling life. Now, these are fine and colorful words. Some fiduciaries take them seriously and apply them in everyday life for the people that they serve. Others don't. And it's my job as an advocate to expose such abuse. While not naming names or locations, I want to describe a few cases where we're asking questions whether these California trustees and their attorneys are meeting the noble purposes described by the Fiduciary Association. A father desiring to set aside assets to benefit his retirement-age daughter creates a trust directing the successor trustee appointed at his death to provide income and principal for her well-being. Her well-being is within a health, education, maintenance, and support standard. In this case, the trustee is a professional corporate trustee. It advertises itself as a trusted source, a preserver of family harmony with high-touch, high-quality services. The father dies, and the trusted source and preserver of family harmony trust company takes over as trustee, using its high-touch, high-quality services. The trust committee of the professional corporate trustee meets and approves a distribution of $2,400 per month to the elderly sole beneficiary. The trust beneficiary lives in low-income housing. Documents provided to the beneficiary show trust liquid assets in excess of $2 million. Money paid to the corporate trustee for trustee, quote, fees and expenses, unquote, exceed disbursements to the beneficiary. So let's step back just a minute. I doubt that the beneficiary's father ever read the corporate trustee's website, but somebody did. Maybe it was the trust attorney. Are the trustee's actions preserving family harmony? Is this trustee really a trusted source? If so, a trusted source for what? keeping an elderly beneficiary in low-income housing while there's more than $2 million in her trust? Think about it. If her father could come back to life, would he say that this is the result that he wanted? That the corporate trustee really is doing high-touch, high-quality service? If this is really so, then the corporate trustee should advertise just what they're doing for this elderly beneficiary. So if California professional fiduciaries are a noble lot, according to their association, are these following actions noble? A sick, dying man, an octogenarian, is assisted by his 2 late middle-aged children in the last months of his life. He creates a trust for the benefit of these 2 children. Much like the trust created for the elderly woman, it has a health, education, maintenance, and support standard. The trust attorney, in a communication to her dying client, calls this a general needs trust. The trust attorney identifies a California professional fiduciary to be the successor trustee after the man dies. The man dies in mid-July 2019. It appears that his trust has more than $7 million in assets. So let's remind us what a California professional fiduciary does. The association tells us that a fiduciary's role is not merely that of a business manager, decision maker, or guardian. It's also a nurturing bond of trust, concern, and attentive caregiving. A fiduciary seeks to support mental and emotional well-being, reduce the stress of changing circumstances or unexpected events, and most importantly, help each client and their families enjoy a fulfilling life. Okay, I'll accept what the association says. Now, let's see how this particular California professional fiduciary applies it. The trustee's attorney sends a notice to the decedent's children approximately 1 month after the decedent's death. The notice includes a copy of the trust. 3 days after the trust notice, the successor trustee serves a 30-day notice to quit and vacate premises on the decedent's 2 children. Their father at this point has been dead 40 days. The California private fiduciary signs the notice as the, quote, owner or managing agent of the father's trust property. The children are informed that they must vacate the premises and surrender full possession to the owner-landlord by September 25th, 2019. They're warned that the California professional fiduciary will use, quote, court proceedings against you, which could also result in a money judgment being entered against you for the balances due plus cost and disbursements of suits and attorney's fees allowed by applicable law. The children, of course, have no tenancy agreement. They're not paying rent. They were in the premises assisting their father in his last months of life. Does it appear that this licensed trustee sees any important considerations outside the legal aspects? The children are grieving. The prospect of moving is challenging. They meet with the trustee. They're told that they will be lucky if they each receive $24,000 each year in beneficiary benefits. $24,000 per year from a $7 million trust made to benefit them. This California professional fiduciary will be given the opportunity to explain how, in the words of the association, these actions are a nurturing bond of trust, concern, and attentive caregiving. The trustee can also explain how these actions support mental and emotional well-being, reduce the stress of changing circumstances or unexpected events, and most importantly, help each client and their families enjoy a fulfilling life. The children in this case sought a mediation with the trustee. The trustee's attorney indicates that the trustee will not mediate until the 2 children vacate their father's property. The trustee will move forward with eviction proceedings, says the attorney. The attorney adds that the trustee is willing to provide the beneficiaries with a reasonable monthly distribution from the time they vacate and the completion of the mediation. The mediation was canceled by the trustee. The actions of the corporate trustee and the California professional fiduciary remind me of the words of Abraham Lincoln with regard to slavery. If slavery is not wrong, nothing is wrong. If a trustee, whether corporate or for-profit licensed professional, can treat beneficiaries the way that these 2 have, then they can do anything. Millions of dollars set aside for the benefit of children beneficiaries. One beneficiary living in low-income housing, the others still in their father's house. One beneficiary given income far below the poverty level, and the others no income whatsoever. If a trustee is to administer a trust solely in the interest of beneficiaries, how are these actions of any interest to the beneficiaries, let alone sole interest? I admire the efforts of Dr. Sam Sugar of Americans Against Abuse of Probate Guardianships, the advocacy of Rick Black of the Center for Estate Administration Reform, the activities of Spectrum Institute's Disability and Guardianship Project, and the courage of Carol Herman of Foundation Aiding the Elderly to bring a bright spotlight on fiduciary abuses and elder abuse. We, of course, have a different role. We're lawyers who represent aggrieved beneficiaries and elders. We regularly enforce trust beneficiary rights. We focus our practice in California's largest urban areas. We take substantial cases where we think that we can make a significant difference, and there's a wrongdoer who can be made financially accountable for their wrongdoing or their breach of duty. I'm grateful that fiduciary abuses are more and more coming to light. If you'd like to speak with us about your particular case of fiduciary abuse, call us at Hackard Law, 916-313-3030. We'll be happy to hear from you. Thank you for listening.